So Olta Andoni is a partner at Bellamentis PLLC, focusing on state regulatory frameworks and fintech licensing and emerging technology law. She's also the executive director of the Illinois Blockchain Association, which is an organization that I'm also part of. So you'll hear from her. Andrew Gordon is managing attorney of Gordon Law Group, and he's a crypto tax specialist. He's by far the leading crypto tax lawyer, in my humble opinion, in Illinois and maybe the country. And he gives advice on federal and international tax issues affecting digital assets, planning for crypto tax planning, and most importantly, he runs a nonprofit digital asset tax action group, and he's in DC like half the time fighting in Washington trying to get clarity on crypto taxes. And then Rob Musiala is a partner at Baker Hostetler, which is an international law firm where he leads the entire firm's Web3 and digital asset team. He focuses on regulatory compliance, including Bank Secrecy Act, FinCEN regulations, money transmission, securities and commodities laws, and he's a frequent speaker on crypto regulation. Great. So that's the most you'll have to hear from me today. So moving on, Rob, I think we'll start with you. A lot of activity involving the SEC and the CFTC since last summer. Can you start by, I guess, describing what I think is the most important action, the joint interpretation? Like what happened there?
Sure. Thanks, Mike. So the SEC and CFTC issued a joint interpretation that provides a lot of very important guidance. The most important part is it creates 5 specific categories of crypto assets and defines which of those categories would be considered securities and which would not be considered securities. So I'll go through those 5 categories. The first category are called digital commodities. A digital commodity is not a security. A digital commodity is defined as a crypto asset that is linked to and derives its value from a functional crypto system, and that also derives its value from supply and demand dynamics, and that specifically does not derive its value from the expectation of profits based off of the efforts of others. So that's the first category, digital commodities, not securities. The interpretation actually provides 18 specific examples of digital commodities, including Bitcoin, Ether, Solana, Avalanche, XRP, and several others. So most established crypto assets in the market will likely fall under this definition.
Rob, is the guidance law?
The guidance is interpretation. So it is not law. It does not have the force of law. And that has certain implications. For example, courts do not have to consider the guidance if they are considering the question of whether a crypto asset is a security. And so we'll go through the rest of the 5 categories, but it's not law, and a court does not have to necessarily consider it. The second category, digital collectibles. These are crypto assets that are intended to be collectible items and that provide rights to certain digital media like artwork, film, music, in-game items, memes. So these are digital collectibles, not securities. The third category, digital tools. Digital tools are not securities. A digital tool is a crypto asset that has a practical function within a crypto system. So something that acts like a membership badge, a title instrument, a digital identity credential, a ticket, or another form of digital credential. These are not securities. Fourth, we've got Genius Act approved stablecoins. So if a stablecoin is compliant with the Genius Act, it will not be considered a security. The implication there is that if there's a stablecoin that is not compliant with Genius, it may be considered a security. And then lastly, the fifth category, digital securities, also known as tokenized securities. And these are financial instruments that are specifically enumerated in the definition of a security and that take the representation of a crypto asset. And so, in other words, these are crypto assets that are intended to be securities from the very start. So you've got these 5 categories, and this is a big win for the crypto market because it does provide, to a large degree, the clarity that the market has been looking for, and it tells us exactly where the SEC stands on this issue. There are still risks, though. The main risk, Mike, as you mentioned, is that it's an interpretation. It's not a law. It does not have the force of law. So that means It could be withdrawn by the SEC at any time, whether that's the current SEC or a future SEC. It could be superseded by a statute, potentially the Clarity Act, and courts don't have to follow it. So if a court has to look at this question of whether something is a security, it's going to look to the Howey test. Is there an investment of money in a common enterprise with a reasonable expectation of profits based on the efforts of others? It does not have to consider the interpretation.
I'm going to go off script a little bit and throw it to the group. Does the fact that the SEC promulgated this guidance mean that the Clarity Act isn't going to pass? Where are we in Washington right now with respect to the Clarity Act? Do you think we're going to get market structure legislation? And if we don't, does it matter?
Is this for us? Yeah. I think that's a great question, especially today, since yesterday we got the new draft that was published. So now we're going to see how that's going to roll out. And for the audience here now, the attention has been shifting. First, we're concerned about staking, if you all remember. So now we're all caring about the ethics provision. I am a very transparent person, and I think that this act, chances for this act to pass are very, very low, unfortunately, at the moment. And I do think, honestly, that both regulators publishing their guidance, I'm not saying that they're hinting at the chance that we're not going to have a market structure, but I think they're kind of preparing us for that. So I think the industry should be ready in case we do not end up with a market structure. Definitely we're going to follow, and we're going to follow, meaning we're going to go back to this rulemaking. We're going to analyze how this guidance is going to be applicable to different businesses, et cetera, and see where we go from there.
Well, someone needs to be an optimist here, so I guess that'll be me. If you check the markets, it's about a coin flip of whether or not Clarity is going to pass or not. From the conversations that I've been having in DC, there is optimism, but at the same time, concern. And ethics creates a whole new wrench in everything. The news a couple weeks ago about President Trump profiting $1.6 billion, not good for all of us in the crypto industry who want Clarity to pass. But to be candid, it must pass. It has to pass for crypto dominance in the country. We need these rules of the road. And I'm very concerned that if it doesn't pass and pass soon, that whatever comes in the future may look vastly different than what we have today. Is it perfect? No, I don't think there's any legislation that's perfect, but it takes us quite a far way from where we've been over the last 10 years. And I'm just very concerned that if it doesn't pass, it may never, or the future versions of it may be the opposite of what we actually want.
But Andrew and Rob, I mean, don't you think that like the horse is sort of out of the barn already in terms of institutional adoption and the market being more mature? Like if it doesn't pass now, does that really matter? I mean, aren't we going to get something similar in a year or two when crypto is less political? Or I mean, do you think it matters?
Well, I think it does for keeping crypto businesses in this country. Over the last 10 years, as an attorney, I've helped countless businesses move out of the country. And it's probably one of the worst things as an attorney I've had to do. You know, I love this country, and I'm helping people create their businesses in UAE or wherever it may be, or whatever the country that has the attractive laws of the day are. Over the last year or two, because of this sense of optimism that we're going to have these new rules of the road, companies have been forming again or coming back to the US. And I'm just concerned that if this shifts, it's pretty easy for companies to move offshore. I think Coinbase has already publicly said, even last week, that, hey, if Clarity doesn't pass, we might be looking outside the country. So I think it is very important in order to keep these businesses here.
And I think from a practical perspective, we probably have two opportunities to get the act passed this year. One is like right now, before the August recess. Then if it doesn't pass by then, there'll be another opportunity before Thanksgiving. I think if it doesn't pass by Thanksgiving, there's a very low likelihood that it'll get passed. And then, to Andrew's point, we don't know what's going to happen. A very different law may be brought to the table.
But it's going to be way harder during Thanksgiving time.
Agreed.
I mean, our only chance is now, in my opinion, next week.
Rob, before we move on to a new topic, it sounds like the SEC and the CFTC have been really pro-crypto, to put it lightly, and since over the past year. Are there any other guidances or actions that the SEC in particular has taken that are significant for the group to know about?
Well, the other thing that I want to point out about the SEC interpretation in particular is that it discusses this concept of how a crypto asset that is not a security can be subject to an investment contract, which is a security. And this is a really important concept to understand for folks working in this space. The guidance goes on, or the interpretation goes on to explain that in those scenarios, the crypto asset can actually separate from the investment contract. And how does that happen? Chairman Atkins gave a speech on this topic where he explained that when a crypto asset is subject to an investment contract, it can separate from the investment contract when either the obligations of the investment contract are fulfilled, the obligations of the investment contract fail to be fulfilled, or the investment contract otherwise terminates. And so when you're dealing with crypto assets under this new interpretation, which could be what we're left with in the short term, this is a very important concept to understand and to understand how it relates to any particular crypto asset that you're dealing with.
Well, let's take a break from federal law for a moment and talk about the awful things that have been happening here in Illinois. So, Olta, could you catch us up to? I mean, the two big developments are the digital DACPA, the Digital Assets Consumer Protection Act rules, and the tax issue. Could you catch us up?
Yeah, absolutely. So regarding DAPCA, I think that's a great development, to be honest, for our state. Just for the crowd, we're trying to have a regulatory regime. I mean, similar to BitLicense, but hopefully a little bit more flexible. So I consider that a great development. And honestly, it's a good step for all the businesses here. First of all, to kind of consider where do you sit as a business on that regulatory regime from a risk perspective. And IBA, since I'm the executive director and I have here our general counsel and board member as well, we did provide a comment letter to the regulator here with, our vision or what we're thinking about the new proposal. But I think definitely it's a great first step. Regarding the regulatory patchwork or the compliance, I would call this a compliance patchwork, meaning that now, if you're a business in different states, you have to comply to have the bid license in Illinois, to have this license in bid license in New York, to have the license in Illinois. So I think that definitely creates some friction. And I am concerned that probably it's going to be like double work on the compliance and regulatory for some businesses. But at the end of the day, that's why I'm saying, like, depends on the nature of your business, and you have to evaluate whether or not this compliance is like a moat in the sense that, hey, we're doing this and we're being regulated in Illinois, or whether or not that might provide like some friction. And in our letter, Mike, as you know, we also mentioned like the definition of control. So, for example, if you are a custodial exchange and you're controlling your customers' keys, definitely you are falling under DAPCA, and that is going to give you more compliance risk. But
so what's this tax that I've heard so much about?
The tax is a big concern right now, and just 2 days ago, my firm advised represented digital chambers in a lawsuit. We're suing Illinois because this tax does have a tremendous impact. It's a 20 basis point, and I have seen like some medias out there saying that, 20 basis point, that's nothing. But I think for some businesses, especially 20 basis point on the tax nominal value and not on the profit, that truly means a lot. I am concerned that this tax provision, hopefully we're going to be able to fight this with the lawsuit, but I think that definitely it's going to have a big impact, and maybe, some businesses might even consider geo-blocking Illinois later on.
Yeah, just to drive the point home, this is the first of its kind tax in the whole country. It taxes every crypto transaction that involves an Illinois resident, and it even taxes storage. So if you're an Illinois resident and you have your money with Coinbase, then 20 basis points are going to be taken out. It's unclear if it happens every day or every month or once a year. There's a lot of vagueness in the statute. So anyway, the first lawsuit was filed yesterday, day before, 2 days ago, and we're hoping it'll stop. But it's a really bad sign in terms of the state's sort of welcomeness to the crypto industry. Anything to add there, Andrew?
Yeah. So the tax is bad, and I'm a crypto tax attorney. Hold your applause. And I love tax, but this is a bad idea on several fronts. One of them being that crypto taxes in this country are already broken. It's a disaster. It's a headache. It doesn't make sense. It's unlike anything else in the modern financial system. When you trade your stocks, you get a nice, beautiful form at the end of the year. You plug it into TurboTax, away you go. With crypto, you've got to keep track of and account for every trade. You've got to hire someone like me and my firm to go through all your transactions. And now we're adding even more complexity. We're adding this additional tax that has to be accounted for. How do you account for it? Is it an added cost basis? Do you subtract it from the sales price? How often do you do it? It's a mess on that front. The second big issue here is what happens next. Some of you may not be in Illinois, and so you think, well, I don't really give a shit. It's not in my state. But the problem with bad state policy is it starts in one state, it moves to another state, it spreads, and then it becomes bad federal policy. And from an administrability standpoint, again, just from a record-keeping standpoint, it's already too difficult. And now you've got to figure out, well, I'm trading with someone in this state, or the exchange I'm working with is in another state. Do I have to add this tax? It's a headache. And it's going to become even worse if this spreads to other states.
Yeah, it's a huge problem. I know we're short on time, and Andrew, you spend more time than anybody thinking about the problems with the crypto tax system in the country. So, and I know you're in Washington advocating for changes. So, what are some of the changes that you hope to see, and where are we on that front?
Yeah, so just a little bit about what's going on behind the scenes. Clarity, hopefully it passes. But regardless if it does or doesn't, the next priority that I've heard from basically everyone in Congress I've spoken to, all the way to the White House, is my favorite topic, crypto taxes. And it's important because that touches all of us. Whether or not each of you will be impacted by market structure, I guess we'll see. But all of you have an obligation to pay your taxes until I change that. But for now, we all have to pay our taxes. There was a recent report by Coinbase that says that 49% of people don't know that crypto to crypto is a taxable event. And I'm not going to ask all of you to raise your hand if you've reported crypto on your taxes or if you've done it properly, but most likely half of you haven't, at least. One of the big pieces of legislation that I've been working on in DC, happy to see it moving forward, is a crypto voluntary disclosure program, a way for crypto investors to essentially reset, to come into compliance, pay taxes for the last few years, not pay a penalty if they come in over the first year. So this is there were 7 bills that were introduced by the House Ways and Means Committee about a month ago. Other issues like staking also front and center, but overall the administrative priority is shifting from market structure, whether it passes or not. Crypto taxes are next.
Okay, I'm told we only have about 5 minutes left. As you can tell, there's just too much to cover in 25 minutes, but I don't want to leave out Genius. I think the big news of 2025 was when Genius passed. But a lot of work has been going on behind the scenes regarding the implementation of Genius and what it means for the stablecoin market. Rob, could you catch us up to what has happened over the last year or so?
Sure. We've had a wave of proposed rules that have put in place the proposed regulatory framework that would interpret the Genius Act. The Genius Act will, even if the rules do not put it into effect first, the Genius Act at the very latest will go into effect January 18th, I believe, of 2027. So this is coming up faster than a lot of people realize. And the proposed rules have been voluminous. There's a lot in there. They cover a range of different areas, but overall, I believe that they're on track, and we're on track to have a pretty robust legal framework around Genius and around stablecoins, and that's going to be a really good thing for the crypto market and for the crypto market in the U.S.
So will I be able to earn interest, yield, from holding my stablecoins in a wallet?
No. So this goes to the heart of the yield debate, which is one of the most hotly debated issues around Genius. On one side of the debate, you have the banks, which say that stablecoins should be a payment instrument like an ACH or a wire, not like a retail bank account. On the other side of the debate, you've got the crypto industry, which says we should let the market be competitive and we should let the market decide If the market wants to pay yield, they should be allowed to pay yield. For now, the banks have, by and large, won that debate. It will be interesting, however, to see after Genius goes live and after people actually start using stablecoins in practice more, how Genius potentially evolves as the use of stablecoins is seen in the marketplace and continues to evolve.
I think we have time for a question or two from the audience, but be careful. One of us may send you an invoice, depending on the question. So.
Thanks. Rob, you mentioned the concept of the investment contract, maybe separating from the actual underlying crypto token. I'm curious, is this similar to the concept we saw talked about a few years ago with the Ripple case, where it wasn't about securities law applying to assets, but rather to transactions? Is this a similar framing or very different?
It has a lot of similarities. This is going to be one of these issues that remains relatively complex, and it will be difficult to draw that line in terms of exactly when the crypto asset has separated from the investment contract. But yes, it is rooted in a lot of those same principles.
Are there any protections for blockchain developers inside any of these bills or applications?
A lot of them, yes. The short answer is yes. So, for example, in Illinois' DACPA, our version of the New York bit license, there's an explicit carve out that says software development in and of itself doesn't constitute your regulated activity. Could one of you guys speak to how that issue is addressed in Clarity? I think there's a carve out in Clarity too for software development, right?
Yeah, I'm not sure if it made the.
I'm not sure if it made the draft yesterday, to be honest. I don't think it made the draft for software developers, but.
But there have been efforts in DC from a federal standpoint. I think we all look at the cases, Tornado, Samurai Wallet, and it creates a lot of concerns for developers. I've spoken to members of Congress who understand those concerns, people that even have software backgrounds and realize that we can't punish the creation of technology. We could hold people responsible for how they use that technology, but to punish developers, that creates massive disincentives to developing technology here. So there has been legislation federally. Hopefully it will make it into the final version of Clarity. To Olta's point, I'm not sure if it made yesterday's draft. Haven't read those 600 pages yet. Looks like it has. It has. It made the 600 pages.
Text. It's not the whole text.
Yeah.
Meaning the section that was from the previous draft, because I analyzed it last night.
Fast reader.
Yeah. The other issue that I've seen is developers develops like a DeFi protocol, and they maintain some level of control. Whether it's upgradable smart contracts or some level of keys, and so the line between developing and deploying autonomous code versus operating some kind of a financial product it can be blurry sometimes, and people have gotten into trouble there. So it's definitely an area where we're not going to have perfect clarity overnight, I don't think. All right, thank you very much.
Thank you very much.